This film is a project of the Annenberg Foundation Trust at Sunnylands. Citizenship is every person's highest calling. Thaddeus Edmonson was a construction worker, not a lawyer.
That's right. I was just a plain layperson.
So when he went to work on the morning of June 18, 1984, the last thing on his mind was that he was about to start a journey that would take him to the Supreme Court of the United States.
I didn't have money to buy grocery. They're going to listen in on this case.
Where his case would help to preserve a fundamental right for all of us, fairness in the selection of juries.
The little man can really win, but you have to fight.
It's one of the strange things about the American legal system that the cases that become the vehicles for announcing these constitutional principles often don't start that way. Sometimes it's sort of an accident.
Thaddeus Edmonson was in charge of inspecting concrete. He made sure that when the cement was poured from the hopper, it was poured straight and smooth.
Straight and smooth. The concrete had to be straight. That morning we were pouring concrete on the incline of a hill.
They were literally making sidewalks, curbs, and gutters when the cement started coming out, well, lumpy.
The concrete is not coming out properly.
You can't have a lumpy curb, so Thaddeus walked between the two trucks to look into the hopper to see what was wrong.
So I'm bending over, looking inside of this hopper, and felt this crushing feeling coming back on me. And I'm hollering, like, stop, stop, stop.
His leg and lower back had been caught between 2 tons of steel. He spent weeks in the hospital, had multiple surgeries, and missed months of work. At first, the company took care of the bills.
And then the paycheck stopped.
Thaddeus couldn't work. His wife was a school teacher, they had 2 small children, and a lot of bills piling up. Thaddeus hired Jim Doyle to represent him in a personal injury suit against the Leesville Concrete Company.
I've always been a trial lawyer. I've always handled courtroom cases.
Jim Doyle had handled everything from civil rights litigation to maritime law, cases about the law and the sea. Thaddeus didn't know it at the time, but hiring Jim Doyle turned out to be the best thing he could have done.
This is the guy I want to have for my case. This is the person I want right here.
Now, a couple of things you should know. They didn't sue Leesville Concrete for millions of dollars. They sued for $420,000 to cover medical bills and lost work. You should also know that while the jury came back and acknowledged that Leesville was a little responsible, they only awarded Thaddeus Edmonson $18,000, a small fraction of Edmonson's medical bills.
We had this long discussion in Jim's office, and I said, no, I can't accept that. And he says, well, we're going to appeal it.
The point of the Edmonson appeal was never about really just reversing the jury verdict. It was about getting him a new trial because he'd not had a fair trial to begin with.
The right to a fair or impartial trial by jury is written in the Constitution. The framers understood that justice had to involve the voice of average citizens.
We have constitutional guarantees of the right to jury trials in the 6th Amendment for criminal cases, in the 7th Amendment for civil cases, and also in Article 3, which creates the judicial branch of the federal government.
The whole notion of creating a jury system was created to prevent tyranny, abuse of power by the government.
Imagine you live in a country with one all-powerful ruler. Now, that person can do what he wants to. So your liberty, your life, your property, all of that hangs on the goodwill of one man.
Only the crown got to make these decisions about guilt or innocence.
And the founder said, we don't like that. So we're going to separate power.
So before you lose your liberty or worse, all 3 branches of government have to participate. The legislature passes a law that determines what's criminal, prosecutors come from the executive branch to enforce the law, and the judicial branch presides over a trial.
And then the jury comes in, because if we're going to do something so serious as take away your liberty, maybe your property, maybe even your life, you don't just have the 3 branches of government, you also have the voice of the people. And that's what the jury is. It protects your liberty against the government. It gives the voice of the people a check on the government.
Which is why serving on a jury is not just an obligation, it's actually a right. And because it's a right, according to the 14th Amendment, everyone's right has to be protected equally. But I'm jumping ahead. Jim Doyle was preparing to appeal the Edmonson case because of something that happened during jury selection. It's commonly called the jury pool, or sometimes by the old-fashioned name
Veneer, or if you're where I'm from, it can also be known as the veneery.
I've been known to say veneer too, but most of the time I say veneer.
There are two stages in jury selection. First, you have the veneer, where you assemble a pool of potential jurors.
You have to start with a very large pool of prospective jurors in any given case.
It's a larger number than the actual 12 or 6 people that will serve on the jury.
In order to get a fair trial, each side wants a jury that it believes will be impartial. So the number of prospective jurors in the jury pool is winnowed down by questioning prospective jurors. That process is called the voir dire, and like the word veneer, it too comes from Latin.
Voir dire, or voir dire.
Depends where you're from.
It's a funny phrase, but very serious business.
Every time a jury is selected, there are a series of questions asked by the judge and the attorneys to confirm that prospective jurors are able to follow the law that will be applied in the case before the court.
Prospective jurors may be excluded from service because they've read too much in the papers and might be biased, or they might know somebody in the courtroom.
Oh wait, it's my neighbor who's on trial. I know the defendant, or I know the prosecutor.
It would be reasonable to think you're not going to be able to view these facts impartially with an open mind. If those reasons are present, then we excuse these people for cause.
Typically, challenges for cause won't narrow the jury pool all the way down to the sitting jury. In fact, there are two ways a prospective juror can be excused. One is to be challenged for cause, and the other is a peremptory challenge, a practice that goes back centuries to English common law.
A peremptory challenge allows lawyers for either side to remove someone from the jury without giving a reason.
So, for example, I just get a bad vibe from a person. I can say, you know what, I don't think I want this person serving on my jury.
If I have a bad vibe, I'm going to listen to my vibes because I've learned over the years that they're generally correct. You know, we communicate in all kinds of nonverbal ways.
The idea is peremptory challenges are sort of for hunches or for reasons that you can't fully explain. You think this juror is not going to be sympathetic to your side.
The number of peremptory challenges each side gets is limited by state law if you're in state court, or as few as 3 if you're in federal court. And while they are very popular with lawyers, they have a troubled history. For decades, peremptory challenges were used to exclude people based on race.
There's a long history of race-based exclusion from juries.
Until the second half of the 20th century, juries were pretty much exclusively all white men, especially in southern states, and often with disastrous consequences. Conviction rates of minorities by all-white juries were much higher, and in some very famous cases, white defendants on trial for murdering black victims were often acquitted despite overwhelming evidence of their guilt.
In order for jury verdicts to have any credibility, you have to have representative juries.
We make a point in this country of saying that it's our goal to treat everyone equally, and that means everybody.
In fact, peremptory challenges are only a fairly recent tool used to exclude blacks and women from juries. First, states passed laws that simply said only white men could sit on a jury, but the Supreme Court said those laws violated the 14th Amendment, so
Other methods of excluding people from juries based on race continued.
minorities and women were excluded from jury pools. In most states, the names of citizens eligible to serve on juries largely come from registered voters. But women didn't get the vote until 1920. The court didn't establish their right to sit on a jury until 1975. Some of your parents still have clothes from back then. And many states denied African Americans and other minorities the right to vote well into the 1960s.
There was no discriminatory use of peremptory strikes in the 1940s and 50s because there were no people of color to strike. And it's only when we diversified the pool from which jurors are being selected that the pressure shifted from the legal exclusion of people in the right to vote to the right to be in the pool to the right to not be struck. And that's why peremptory strikes becomes the latest and most critical part of this story.
By the time you get to the mid-20th century, the practice has actually been enshrined in prosecutors' manuals in some cases. So there's a Dallas, Texas prosecutor's manual that says explicitly, if you're prosecuting a member of a racial minority, strike other members of that minority from the jury.
The Supreme Court declared that practice unconstitutional in 1986 with its decision in Batson versus Kentucky.
Batson's a very significant decision. What Batson says is you can't use a peremptory challenge based on race.
The court held that a prosecutor using a peremptory challenge to remove a prospective juror because of race was a violation of the 14th Amendment's Equal Protection Clause. The prosecutor is a government official, and the 14th Amendment says that the government must treat everyone equally.
Batson basically says, if the prosecutor is striking minority jurors, you can say, looks like you're doing this based on race. Give another explanation. So you would make the prosecutor come up with the neutral explanation. You know, it's not race, I'm doing it based on education or wealth or something else. And if the prosecutor can't do that, then the peremptory can't be used that way.
Batson is such a well-known case that, to this day, when a lawyer charges another lawyer with trying to use a peremptory strike to remove a prospective juror because of race, that's known as a Batson challenge.
It was a very big sea change in the way that courts and trials were handled. There was an enormous amount of resistance to it.
The court was aware of how disruptive this could have been to peremptory challenges in general, a practice that was older than the nation itself, so it took a very limited stance in Batson. Batson applied only to situations where the prospective juror who was challenged was the same race as the defendant, and it applied only to the prosecution, meaning the government, in criminal trials. But Edmonson versus Leesville was a civil trial, one private party acting against another private party to recover damages.
The general principle in the background here is that the Constitution only protects you against the government. So the Constitution says the government can't discriminate against you on the grounds of your race generally. It doesn't say that I can't. So if I am having a dinner party, I can invite people based on race, if that's what I want to do. The Constitution doesn't have anything to say about that.
Comparing Batson to Edmonson criminal trials to civil trials was like comparing apples to oranges. So back in that federal courthouse in Louisiana, when Leesville Concrete's lawyers used the peremptory challenge to strike two black men from the jury in a civil trial, Jim Doyle wasn't sure if Batson even applied to his case.
Batson had just been decided. Of course, it was a criminal case, and this was not a criminal case that I had.
So when Doyle made a Batson challenge and asked the judge to make Leesville explain why they had just struck the two black jurors, the judge had something to say.
The judge was quite upset with me, I'll put it that way. He took me back into his chamber and said, I can't believe you're going to make this argument.
I think you could fairly say that Mr. Doyle was pushing the envelope, as he should have been. Batson was a criminal case. It was decided merely a year before. So absolutely, it was not surprising that the trial judge said, hold on, what are you talking about?
I knew they couldn't give a race-neutral reason, and he wouldn't do that.
So because the judge let Leesville strike the two black jurors,
I can't accept that.
Doyle and Edmonson appealed the Leesville peremptory challenges. This case wasn't just a personal injury suit anymore.
Along the way, it changes. It turns out that there's this big constitutional principle sort of hiding in the background, and it comes into play in this case, and all of a sudden it becomes not about personal injury, but about equal justice under law.
The appeals process took 3 years. They eventually lost their appeal because theirs was a civil trial, and the appeals court ruled that while the 14th Amendment guarantees equal protection, it applies only to the government, not a private party in a civil suit. Thaddeus Edmondson had reached rock bottom.
I had no money. I lost my home. I'm saying, Jim, I understand the Constitution. That's well and fine, but I've got to eat. He said, but if you give up now, you hadn't achieved anything.
Doyle convinced Edmondson to keep going. They were fighting for a principle now.
If we don't have a fair, open, honest, colorblind justice system for everybody, we don't have it for anybody.
Jim did a lot of stuff pro bono. He didn't get paid.
It demonstrates a remarkable level of commitment to his client. It is not the norm to see a trial lawyer argue in the Supreme Court.
Nothing about Jim Doyle was normal. In fact, this wasn't even Doyle's first trip to the Supreme Court. Just a month before his argument for Edmonson, Doyle argued a maritime case there, and to put it nicely, he could have done better.
Yeah, lost 9-0, and it was not as close as the score indicated.
Oh, my goodness.
This was news to Thaddeus Edmonson.
He never told me that. He never told me before the Supreme Court. Oh, man.
On January 15, 1991, Jim Doyle was at the Supreme Court again, this time arguing the Edmonson case. This is the actual audio recording from that day.
May it please the Court. The issue in this case is whether Batson v. Kentucky applies in civil cases in the United States District Courts.
Doyle has to convince the court that the Constitution applies to Leesville, which is not the government, but a private company.
He argued that this isn't a private action. The exclusion of American citizens from jury service cannot be viewed as a private action.
Leesville's argument was simple. The 14th Amendment doesn't apply to us.
If we want to use our peremptory challenges on racial grounds, that's okay.
Doyle ended his argument pleading with the court to remember not only the rights of Mr. Edmonson, but of the 2 black jurors who were excluded from the jury because of peremptory challenges.
And in general, the closing went something like this. This case is not just about my client, Mr. Edmonson,
or about Leesville Concrete Company. This appeal also concerns 2 men who are not represented by counsel and are not here today, Willie Combs and Wilton Simmons. They are the 2 black jurors who were excused from jury service. We don't know much about Mr. Combs and Mr. Simmons. We don't know much about them because trial counsel saw no need to ask any questions before he challenged them as jurors. Mr. Combs' parents and his grandparents could not have served on a jury in Louisiana, not because they weren't fit or qualified or competent to do it, but because they would not be allowed to do so because of the color of their skin. On that July day in 1987, Willie Combs and Wilton Simmons entered the federal courthouse in Lake Charles, Louisiana, believing that times had changed. They were confident that justice in a federal courtroom would be guided by the promise that they would be judged not by the color of their skin, but by the content of their character.
And when I said that, you could have heard a pin drop. The things I remember the most about it were Justice Kennedy, who was up on his elbow just boring into me when I was making this statement. And I remember when I sat down, Justice Thurgood Marshall looked at me and winked.
The court handed down a 6-3 opinion in favor of Thaddeus Edmonson. Justice Kennedy wrote for the majority.
The majority says the Constitution does apply to Leesville, even though it's a private company, because it's acting in a context that's created by the government. Obviously, 2 private parties can't have a trial by themselves. You need the government to create the court system.
Justice Kennedy wrote that the jury exercises the power of the court and of the government. If a government confers on a private body the power to choose the government's employees or officials, such as a juror, the private body will be bound by the constitutional mandate of race neutrality. Leesville was in violation of the equal protection rights of the 2 black jurors, as well as Thaddeus Edmonson, because peremptory challenges are a function of government, even in a civil court, so they cannot be based on race.
If you use our court system, even if it's a civil case, you've got to abide by our rules. And one of our rules is you don't get to exclude people in a biased or discriminatory manner.
Justices O'Connor, Scalia, and Rehnquist dissented. Justice O'Connor, who had voted with the majority in Batson, dissented in Edmonson, arguing that a peremptory challenge by a private party in a civil suit was not a function of government. Justice Kennedy ended his opinion by explaining why this case was so important.
Justice Kennedy talks a lot about what effect there would be on the perception of justice if we had a process that permitted qualified American citizens to be excluded from service for no other reason than the color of their skin.
Justice Kennedy concludes by saying that the injury caused by the discrimination is made more severe because the government permits it to occur within the courthouse itself. Racial bias mars the integrity of the judicial system and prevents the idea of democratic government from becoming a reality.
He recognized that everyone has to believe that they have a fair opportunity to have their case, their controversy heard.
Everybody in this country has a vested interest in a court system that is transparently fair. We can't have a judge sitting in a robe in a federal courtroom in front of a United States flag and giving rise to a racially based peremptory challenge. It's just not right.
We won, we won, we won. I said, I'm happy for you, Jim, because you're man, I owe you. I owe you a lot for what you've done.
The irony is that after going all the way to the Supreme Court to ensure that he got a representative jury and a fair trial, Thaddeus Edmonson settled his case with Leesville Concrete out of court and not in front of a jury.
They made an offer that I said we can live with it.
For years after Batson, in case after hard-fought case brought by average citizens like Thaddeus Edmonson, the court expanded protections for jurors against peremptory challenges based on race and gender. In the end, Edmonson closed the circle. What was unconstitutional in a criminal jury was unconstitutional in all juries.
The importance of a jury of one's peers is it builds faith in the judicial system. It is a group of people who are just like me and just like you, looking objectively at facts and deciding what is right and what is not right in a given case, and that we can put our trust in.
Jurors exercise the power of government, they stand in judgment on their fellow citizens, and they stand there in order to make sure that the government plays fair. In our society, positions like that of juror, they're open to everyone without regard to race.
It is the right of every American citizen to serve on a jury.
You should want to be on a jury. People have fought for the right to serve on juries because it's about the character of justice in our society. And if we deny rights to have people serve on juries, we are denying justice.
On June 21, 2019, the Supreme Court overturned the conviction and death sentence for an African-American man who had been tried 6 times for a quadruple murder by the same prosecutor with a history of racial bias in jury selection. The ruling in Flowers v. Mississippi reinforced the court's previous decisions, including Batson v. Kentucky, decided in 1986, that prosecutorial bias in jury selection is unconstitutional.